that there seems to be a hand in all this that we've spent the last 2 days discussing. And if memory serves me well, you denied. Now, my proposition to you is all that we've discussed about these investigations and aiming at the generals and the PKTT is wholly outside the mandate of IDEC as we understand it, as contemplated in terms of Section 7, 1 capital A. That's my assessment. And if you strongly deny that there is a hand in this, I would like you to explain to the commissioners on what basis, because this entire effort and exercise cannot have been to the benefit of IDEC. It's not to the benefit of the country to flout legislative prescripts in the manner that it would appear have been flouted by IDEC consistently and deliberately, and then to offer an explanation for why IDEC would conduct itself in such a manner, which conduct has the risk to destabilize the law enforcement environment and institutions. Thank you.
Chair, I did indicate yesterday, especially having been shown documents that I had not had sight of previously, if I can allude to perhaps two, is having a set of, if I get my days mixed, sorry, but having a set of 4 A1s taken by a person, Mr. Perama, then you have 4 A1s taken by Mr. Mansa, on a date when they are all supposed to have been together, executing one function together with the prosecutor. It's not for me to determine, I'm sure that exercise will still be done through your engagement, on which is the right set of affidavits, supplementary affidavits. That is one example. Closer towards the end of the day yesterday, I'm given a file, and in that file, we have the Public Service Commission report, dated 2023, Commissioner Kumala, which I see for the first time. I only allude just to these two because they're very pointed and they're very factual in the nature of what is before us. I have had to ponder why we find ourselves in this position as IDEC, and why, while I accept, and I don't think that there's meanness when questions are posed by the Commission about, but why you didn't know you should have read. I think the Commission understands I can't read everything and won't know everything, and I do have to trust and rely on my people. And I sat with a conundrum last night of why weren't these things brought to my attention? And if, especially with the Public Service Commission report, which is somewhat quite different, it should have stopped the day the report came in, because it should have been brought to the attention of the ID to say, ID, look, we thought we have a right to investigate this, but here it is. It has been done. Findings had been made. That would have set that matter aside. That was not done. And now the question is why? Why wasn't I informed of the different statements? And what is the purpose then, chairs and commissioners, and forgive me if I'm rambling, but I have to think it out loud because it does not make sense. And I'm saying that there must then have been something else going on that I was not aware of. I cannot tell you what the something else was. I wish I could. I'm not therefore disagreeing with your counsel. I just needed to put it in a way that I am able to, unfortunately, not reconcile, but try and understand about what it is that was going on. You can't reconcile yourself with bad when at all times, I know that I made mistakes as the head of ID, non-intentional, and a lot of them are perhaps administrative things. But at no stage did I apply my mind in a way to seek to to vilify anyone. And so when you don't always have the full knowledge of things, I think the challenge I sit with commissioners is how will we as IDEC will only be 2 years old on the 19th of August. And as a young institution, what will be the mechanisms that have to be put in place for these underlying hands, persons and personas not to have the kind of influence there seems to have been had. I'm unable to take it further than that.
What could the something, as you put it, possibly have been? Surely you must have your ideas. Because one could easily say it was improper motives. But I'm not necessarily suggesting that. I want your own thoughts. What could the something possibly have been?
There's something, Commissioner, also from my time at the DSO, the Scorpions as they were. A lot of the times, and history had shown that, you find that staff get overzealous in wanting to present their case. But more often than not, you find that they engage with persons outside the purview of the work we're supposed to do, and you are not privy to that engagement. Mm-hmm. And so the mind you expect them to bring to bear on the mandate and on the cases is what you're engaging them on. It has been a past experience. In the way things happened this past week, it seems that there are other actors that might have been engaged with for us to be where we are.
And when you talk about other actors, are you talking about undue influence, perhaps?
I don't want to put it so harshly without having any,
Okay.
but to say that persons might have, for motives known to them, cast certain narratives or provided certain information. And you find that without of necessity, because what you expect, everybody gives information. Lots of people like to say lots of things. Do you verify it? Do you consider the source? And do you ever stop to ask, why did that source come to you? It is a question I've had to ask in those very painful few days you've had with me on the Section 27 referral of Adams. How it came about, what was the purpose, and look at where we are today.
But you cannot seek to extricate yourself, as you appear to try to, from what happened, especially with regard to what you just referred to, which is the Section 27 referral. That was there for you to see, and right from the first day, we took you through that document, and you agreed when I suggested to you that it had open quote nothing close quote. You accepted that when I so suggested to
Correct.
you. So you cannot seek to say others may have acted wrongly. I will say to you, you too acted wrongly, and if there are questions to be asked about why, those must relate to you as well.
Correct.
On a document or on an affidavit that had nothing except for factual conclusions, you acted. It had to be your decision, you as the head of IDEC. It had to be your decision, and indeed it was, for any investigation to have gone on in the first place. Cut a long story short, I do not understand why you would want to blame others.
If I may.
As it should have, the buck stopped with you. And indeed, from where I'm sitting, it did.
And that is why, as I was carrying on with the Adams matter, that brought starkly home, from start to finish, the
Yes.
responsibility across the board.
Yeah.
In the first two instances, there are different instances that I used, as I hadn't been aware of them. But I sit here today knowing that I have to take responsibility
Yes.
for all the actions that flowed, intentionally or unintentionally. And I will be judged for those actions.
Yes. But why I'm going back to where we started on the first day of your testimony is because in the context of blaming others, you are referring to the Section 27 affidavit. And it is in that context that I say you cannot blame others.
It is my responsibility.
It is and it was your responsibility.
I accept that, Chair.
Thank you.
Thank you, Chair. Thank you. Advocate Johnson. As I indicated, I would like to move to a different topic. I have a few small topics to cover with you quickly, and I hope we can wrap that up in an hour. We now have it wasn't a promise, but a new hope that you'll be done by lunch. I hope to at least deliver on that one. Okay. The next issue is, do you have your statement file close by? And in particular, the first October 25 statement. And at page 10, paragraph 30, you indicate once the investigation was concluded, this is the investigation following Mr. Adams's Section 27 referral. Once that investigation was concluded, you say you were briefed by the team that had conducted the investigation on behalf of IDEC. IDEC then applied for warrants of arrest against the accused. I then prepared a prosecution memorandum and submitted same to the Director of Prosecutions, together with a draft charge sheet and a request for the enrollment of the matter. Now, that prosecution note, memorandum you prepared, is in file 8, page 3256. If you could lay your hands on file 8. It starts at 3256. And at 3257, paragraph 11, you state, Section 9.1 of the National Instruction 11/2017 states as follows: a selection panel may not be biased and must ensure that the selection process is free of nepotism or favoritism. A panel may never abuse its authority, and panel members may not influence each other to be influenced or to abuse their authority. So you're quoting from the National Instruction. At 12, you state, evidence collected proves that accused 1 to 6, these are the members, contravene the provisions of the above quoted sections to the benefit, I guess, of accused 7 without just or reasonable cause. In your paragraph 30, you indicated you were briefed. I take your use of the word at least implies engagement with the investigators to satisfy yourself that the charges suggested to be preferred against the accused have some factual and evidentiary basis. Is that a fair assumption on my part?
That is correct. The prosecutor would
Now,
also.
you stated paragraph 30, you prepared this prosecution memorandum, so you were armed with all that information. Are you able to quickly enumerate the basis on which you say the evidence points to the contravention of the provisions of that instruction by accused 1 to 6? What convinced you of the contravention? And at least, if we take the wording of Section 9 quoted, it must show nepotism, it must show favoritism.
Sorry, I can't remember all the facts, except for what comes to mind, and I'm sorry if it's short.
No, accept it.
I think what comes to mind is that the selection panel tampered with the panel documents. The panel wasn't who they initially purported the panel to be, and when the investigation started, they had removed pages and inserted new pages, and that's what I recollect is in the docket. And there was an expert who does indicate that there was a tampering with that process, of the panel process, to misrepresent who in fact was the panel. And the only other thing I can recollect, and I don't mean to frustrate the commission, I haven't got the docket. The other thing that I can recollect is that there was a document created allegedly by one of the accused to give the impression that the process had been approved, but the person who should have authored that document was unaware that this document had been created and authored. It therefore gave credibility to the process and to the panel, which would not have happened had this not happened. And I think finally, the only other thing I do remember is that there was fraud or a fraudulent averment in the CV, which was deliberately not picked up so that a candidate could go through. But, sorry, Commissioner, that's the only ones that I can recall from my briefing with the prosecutors on that.
I'm happy with that, and in fairness to you, I'm asking you to recall off the top of your head, so I'll accept what you say. The panel, you say that the panel was changed. That's your understanding?
That's my understanding. And that apparently there's a document expert report that would show how pages were removed for a list of changed names to then be inserted.
Panel.
Yes, but I haven't read that report. But I'm aware that there is such a report.
Okay, I don't know if you're able to follow Colonel Padiachi's testimony, because insofar as the panel is concerned, we are not aware of such a claim. The only complaint would appear as reflected in an affidavit, in a statement provided by General Khan, that the only issue was that the panel did not include General Khan. But there was no suggestion otherwise of a manipulation of the panel. Are you aware of that testimony, that the complaint was that General Khan was excluded from that panel?
No, I'm talking about something completely different.
Okay.
That there was when they are, the way it was explained, when they're done with the documents, they have a way of stapling the documents so that no one can tamper with the documents. I think it's a police process for security reasons. And it was found that the documents, in the way they were bound, was tampered with for an insertion of a different page. And the expert is able to say that the documents were tampered with and something else was inserted. How that is all legitimated, I'm unable to explain.
Now,
it was different from what, what's his name? Mr. Padiachi. I'm not talking about that. I'm talking about something completely different.
Okay, and now this, and that insertion of this page, is that what reflects the manipulation with the panel, as you understand? Okay. The investigator and the docket does not suggest anything of the sort. I haven't come across it. I don't think anyone has in this commission. If the docket provided us is to be believed and accepted, but nonetheless, I'll leave it there. You proceed then at 3257, no, at 3258 to speak of the urgency. So if one has regard to 3257, pages 3257, 3258, would it be safe to assume that the charges against these accused would technically be for or revolve around the breach of Section 9 of the National Instruction and would involve nepotism and favoritism?
Correct.
The charge sheet is attached to your memo. It starts at 3260. What I find in the charge sheet are significant, I think in respect of each charge, is extensive invocation, reference to an invocation of the provisions of the Prevention and Combating of Corrupt Activities Act 12 of 2004. I'm trying to marry the content of your memorandum, which complains in large part of nepotism and favoritism, and trying to understand how that lends us into PRECA, because the charges they face are predominantly PRECA-related. In circumstances where their charges based on PRECA, including gratification and I think commission of crimes in the future, don't find reflection in the original memo. How do I reconcile the two?
Sorry, for someone who wants to be out by lunchtime, I'm not reading very fast, am I?
It's okay, take your time. You haven't seen these in quite a while.
So for some of them, I see them on page 15.
Please reference the red number at the top.
This one.
You said page 15. I think you are looking at the typed page of that whatever document.
No, it's got a black number.
Okay, the 3,000 and something top number. Are you in file 8?
So yeah.
Or are you working off your own copy?
I'm working on the chart sheet.
The chart sheet starts at file 83260.
3260. Okay. Sorry, I was in there.
Yes.
Relevant to the memo on 3267 would have been points
3267.
points 12.12, 12.13,
Okay.
12.14. We agreed about 12.15. I'm not going there.
So 12.15 is out.
Yes, I
Okay.
think Commissioner Kumalo and I dealt with that part of the gratification quite at length, so
Yes.
that falls away.
So 12.12 speaks of accused 7, and that is Mrs. Mkwele, submitting false and misleading information in application and curriculum vitae. 12.13 is misrepresentations made by the accused with regards to the verting of accused number 7. And 12.14 speaks to accused 1, 2, 3, 4, 5, and 6 abusing authority vested in them by disregarding and not complying with SAP's national instruction. I'm still trying to get to PRECA. And based on the content of your own memorandum, because that memorandum, you recall, you submitted to the DPP?
So at the time of the memorandum,
Yes.
we had worked on that which is in 12.15, talked about the gratification in the form of employment. But since we've had the conversation, that's what I'm saying to you falls away. It no longer finds place there.
But it's got a different problem because your memorandum doesn't even invoke PRECA at all. It speaks of no gratification. It speaks of nepotism and favoritism. That's the point I sought to make earlier. That if your memorandum is intended to inform and advise the DPP, the only instrument you invoke at your paragraph 11 is section 9 of the National Instruction 11 of 2017, which you quote verbatim, and that speaks to nepotism and favoritism.
Is it maybe, and this is the best that they can do, paragraph 14 of the prosecution memo? That's the only reference to gratification.
Yeah, that is quite correct. You see what Commissioner Kumalo helps you with, reference to 14, that's your gratification. Now, you say after engagement with the commission, you have accepted that the gratification can't stand. Now, cause of my difficulty is that the charge sheet is with you as you prepare this memorandum. And in fact, in the memorandum, you say the draft charge sheet is attached. And yet, I seem to pick up a disjunction between your memo and the eventual charge sheet. I thought maybe I'm misreading the memorandum, and you might be able to help.
The charge sheet, sorry, the memorandum is a summary, but the charge sheet is also attached so that the DPP is able to apply her mind to both the prosecution memo and the charge sheet. So where one may have missed something in the summary, she is fully within her right, as is always the case, to go through the charge sheet and to also raise questions about the charge sheet and or any deficiencies in the charge sheet.
You recall when, I think it was on the first day or the second, you explained that your referral of the charge sheet to the DPPU as the IDEC, it's not to seek the DPP's approval, but to inform the DPP in whose jurisdiction you intend to prosecute, that you are enrolling the matter. So it's an information sharing exercise.
No, but I say twofold. I did say twofold in the affidavit. I said twofold. It also is its own checks and balance, that if there is anything, because the DPPs also have a right to ask questions and to engage the document. I did say that in the affidavit. They're not a rubber stamp. And I don't believe that that's the impression that was created, commissioners, in...
Probably the error is mine. I might have gotten a wrong impression.
Sorry, I said in the original affidavit was the first is the DPP is a measure for checks and balances. The second is so that the relevant DPP may grant permission for and or agree to the enrollment of the matter unless satisfied on the information given to him or her that there is reasonable and probable cause for the prosecution. The DPP will not place a matter on the roll for criminal cases. So it does give them latitude. They are not a rubber stamp.
I accept that. What is the purpose of a prosecution memorandum? It is to enable the DPP to precisely discharge the functions that you just enumerated, to enable them to make a decision. Do you consider your prosecution memorandum sufficient for that purpose? If the DPP would potentially read the two documents in the manner that I have and not see a correlation between the memorandum and the charge sheet. Because if they would, then they ought to have declined to prosecute on the basis that I don't understand where the charges, what the charges arrives from, because they are not covered in your prosecution memo. Am I being too pedantic?
I think counsel is entitled to her view.
Yes.
And I give respect to the colleague who went through this exercise, applied her mind, and was satisfied that based on the memo and the charge sheet, it was adequate.
The charge sheet is fully supported. Okay.
Yeah, I was going to ask, in fact, what it is that the DPP has. You give them the prosecution memo,
Yes,
and
ma'am.
then you give them the draft charge sheet.
Correct.
Is that all that they have?
That is all we give them.
So where a charge is about vetting, so I know we've had that conversation, but I want to use that as an example.
Okay.
That you have a count here which accuses Brigadier Mukwele in relation to her vetting position. And I think that's the very last count, where you say accused 6 acting in concert with accused 7. I'm looking at page 3279. It's the very last count. And it's just wanting to understand the conversation with Ms. So if you look at 3279, that's the very last count. And in there, you're describing what accused 6 and 7 have done. And then you say, accused 6 acting in concert with 7, unlawfully, falsely, and with intent to defraud, give out and misrepresent to the SAPS, National Treasury, the public, that accused 7's application for security vetting was registered on the e-vetting system when in truth and in fact, accused 7 application for security vetting was registered on the old Ingwazi system as a service provider. That's in the charge sheet. There's nothing about it in the prosecution memorandum, no detail whatsoever. And if all that the DPP has, or had at the time, was the memo and this draft charge sheet, how could they have properly exercised their mind to approve this particular charge, for example, because they have nothing else? And it seems Ms. Silo must be correct to say, on this charge at least, the DPP should have said,
asked.
no, we can't have that unless you give me more. You accept that?
I accept that.
Okay. So at least on this, I mean, I'm not talking about the others. On this, at least the DPP doesn't seem to have properly exercised their mind if all they had was your memo and the charge sheet.
Correct.
Okay, thank you.
It's the same with saying,
Wanted to say something?
Sorry, Commissioner Kumar. What I wanted to say is, in such matters, more often than not, and not just in these matters. In a lot of other matters, what we tend to do is we will send it to the DPP. We also do indicate, kindly contact the prosecutor should you require clarity. And sometimes those conversations happen. I don't want to create the impression it happened here. I'm just saying there is room for engagement, and then they make up their mind. But there is also that process. I'm not saying that it did or didn't happen.
You don't have, you're not suggesting here it happened because
No,
we don't have a record.
we don't
of
have
that
a record,
happening.
yes.
Okay, thank you.
I was going to say, it's the same with the charge that in her CV, she misrepresented facts, but the charge sheet does not say what fact is misrepresented and what is the correct fact. And Commissioner Baloyi's point that the DPP in file 62438, all he or she then says is that having considered your memo and the charge sheet, they are satisfied that a prima facie case has been made out against the accused, and they concur with your decision to charge them. So it means they only considered the two documents that Advocate Sello and Commissioner Baloyi are referring you to. And it's the following day. I mean, there wasn't even a week to consider and come back to you and say, where is this, where is that? What is inquiry? What is e-vetting? They seem to have rubber-stamped what was in the charge sheet, and there wasn't any engagement or consideration, because I doubt that any such engagement would have taken a day to finalize.
I accept that, Chair.
Thank you, Commissioners. Now, do you know when the decision was taken to prosecute the 7, had SAPS advised or sought to interdict the employment of Mrs. Mukwele? Was it suspended? Do you know what became of her?
No,
You're not aware?
no.
Having taken the decision to prosecute, did IDEC at least make a formal request to the National Commissioner to say we are proceeding